My name is Molly, housing paralegal with the Texas Rio Grande Legal Aid. Joining us today are Matt Garcia, Elizabeth Bada Davila, Miranda Canedo, all our housing attorneys at TRLA, and Ileana Riojas, project coordinator for San Antonio Community Housing Rights Team. How's everyone doing this evening?
Doing great. Thanks, Molly.
Oh, wonderful. So Texas Rio Grande Legal Aid has been serving 62 counties in the Central, South, and West region of Texas, focused in different areas of law, such as employment, immigration, consumer, family, housing, tax, and other fields. Our work covers vulnerable individuals, people that otherwise may not have access to legal representation, such as farm workers, victims of domestic violence, homeless people, and low-income persons. But in today's presentation of tenants' rights, evictions, and CDC Order, our attorneys will be addressing common questions on such matters. You ask, how do you get your question to our attorneys? Simply place your question in the Zoom chat feature. If you are connected to the phone line, you will not have access to the chat feature. So please contact us directly via email or phone if you have a question you would like to ask to follow up on. But due to the protection of confidentiality, please refrain from sending any personal information about your legal issue. If you have a specific question related to your own personal legal issue, please contact us privately via email at spelled out right to counsel, RIGHTTOCOUNSEL @trla.org, or you can call 210-212-3703. We have people standing by ready to answer your call. Matt Garcia will be leading the Know Your Rights presentation, and Miranda Canedo will follow up with the workshop session. What's up, Matt and Miranda? How are y'all two doing?
I'm doing well. Great. Thank you.
Wonderful, wonderful. Well, in our season finale of the show of Know Your Rights, we are going to go over these frequently asked questions and common situations. And like I said, we're going to find out exactly how do you complete a CDC workshop by Miranda.
All right, so we're going to be providing some basic information about tenants' rights today, but it's important that if you are a tenant and you have questions about your rights and obligations, that you also look to your lease. Every lease is going to be a little bit different, so it's important that you look at that document specifically. It's also important to note that we are not your lawyer. We're not representing you, but we're just here to provide some general educational material and information. But if you are in a situation where you do need an attorney, you're welcome to apply for our services, and then we can discuss your individual case.
Got it. Okay, so some of the common questions are common problems. What are the common problems that most tenants deal with, Matt?
So one big one that we see a lot is repair issues. If you've got something that you need your landlord to fix in your unit, another issue we often see is lockouts. Landlords either changing the lock on their tenants or not letting them enter in some way. Utility shutoffs is another big problem. Landlords terminating electricity or water service to tenants. Some landlords also have late rent policies. So if your rent's due on the 1st, but you're not able to pay it until later in the month, some landlords will charge late fees associated with that. And then there's a host of other lease violations that some tenants have to deal with, but you'd have to look to your specific lease to figure out what your obligations are and what qualifies as a violation.
Great, great. Okay, and can you explain some of the tenants' rights? What do you mean by tenants' rights?
Yeah, so one big one is a right to proper notice. We're going to get into some of the specifics of this later, but you do have a right to be notified if your landlord decides to pursue an eviction. You also have a right to repairs, and this encompasses any conditions which might materially affect your health and safety. If you do need repairs made for conditions like that, it's important that you make a request to your landlord in writing. It's also important that your rent be paid at the time that you give the request in order for your landlord to be obligated to fix that condition. It's best to send that request through certified mail. That way you get a receipt, you've got proof that you made the request, but it can also be sent through regular mail or in person. We do really encourage that those kinds of communications be in writing, whether by email or text message, so that you have some record of it.
Okay.
There's also a right to report. So you are allowed to call 311, for instance, if you suspect there might be a code violation. You're also permitted to reach out to the city council or to the police. So you have the right to report to those authorities. You also have the right to record. If you're having a conversation with your landlord, you can use your phone or camera in order to record that communication. You also have a right to a hearing in eviction proceedings. Your landlord cannot simply evict you without going through the proper court process. You do have a right to say your side of the story and your version of events and get that hearing before a judge. You also have a right to request reasonable accommodation. So if you have some sort of disability and you need something fixed in your apartment in order to accommodate that, or if you need a change in rules or policies that your landlord has in place in order to accommodate your disability, you have a right to that. There's also retaliation protections. So if you exercise some right that's granted to you under law, like calling the police if you're in danger, your landlord is not allowed to evict you based on the exercise of your rights. Another thing to keep in mind through all of this is that you always have a duty to pay your rent in accordance with your lease. So Texas does not give tenants the right to withhold rent because the landlord is not providing certain services or they've failed to make repairs. So it's always important that you do your best to make those rent payments.
Got it. Got it. One thing that I'm hearing a lot as a housing paralegal is we're in the COVID-19 pandemic crisis. Can people actually get evicted during COVID-19? And there was a recent comment that was made by someone that said that they heard somewhere somehow that landlords are supposed to pay people if they evict people in COVID. I mean, can people get evicted, first of all, during COVID-19 pandemic crisis?
So people, yes, they can be evicted during this pandemic. You can be evicted for non-payment of rent. You can be evicted if you stay in the unit beyond the end of your lease, or if you engage in criminal conduct or breach your lease in some other way. Your landlord is still allowed to evict you. And again, you should pay attention to your lease to figure out what your obligations under that lease are. But there might be local, state, or federal protections which apply in your situation. And one of the big ones right now is an order that was issued by the Center for Disease Control and Prevention, the CDC. They issued an order that temporarily pauses evictions for certain tenants until December 31st of this year, until the end of the year.
Okay. So how does that person know if they are actually being evicted?
So your landlord is required to provide you a written notice to vacate before the landlord can file the lawsuit to evict you. That notice to vacate must give you a 3 days notice, but there are some leases that shorten that time period. So again, you have to look to your lease for that specific detail. If you're in a CARES Act property, and we're going to talk a little bit more about that in a second, that notice to vacate must be a 30-day notice. So that's the very first step in the eviction process, is your landlord's going to give you that notice. And that's how you know that you're sort of on that track in the eviction proceeding. The next step is that the landlord will then file an actual lawsuit in Justice of the Peace Court. Then you would receive a citation from the court telling you when the hearing is going to be and where it's going to be. Then you'll have your hearing and your opportunity to tell your side of the story to the judge. And then the judge will make a decision based on that hearing. And it's possible that a writ of possession would be issued by the court, and that would enable the constable to post a notice on your door, giving you 24 hours notice that they'll return to remove you and your belongings from the home if necessary.
Okay, got it. So I suppose you could also find more information on the eviction process on our website, right? trla.org, like on the slide you see before
Yes.
you on
Yes,
the
that's
screen.
correct. And I should also note that Texas has an eviction diversion program. And this allows landlords and tenants to agree to participate in that program, and it can cover up to 6 months of rental assistance to cure rent. Again, both the landlord and the tenant have to agree to participate in that program. There's a hotline that you can call to find out some more information, 1-800-525-0657.
What landlord would say no to 6 months of rent, right? Okay, so what does the CDC order actually do, though? I mean, really, what does it really actually do?
So it pauses evictions for certain tenants until after December 31st, 2020, until the end of this year.
Okay.
The order temporarily pauses evictions only for not based on non-payment of rent for eligible tenants who provide a declaration to their landlord. The order, however, does not cancel or forgive rent. It also doesn't prohibit landlords from charging late fees or other charges that are authorized under the lease, or for evicting tenants for other reasons not related to non-payment, such as a lease violation or disturbance, things like that.
Okay, got it. And like, this is another very common question that everybody's always asking. Is everyone protected under the CDC order? I mean, can anybody just go up and print one and they automatically are protected under it?
So it is a pretty simple process, but there are some very important steps that a tenant has to take in order to receive the protection. And there are certain qualifications that a tenant has to meet in order to be covered. So you have to get that declaration and you have to fill it out. That declaration is going to have several statements that have to apply to you in order for you to receive the protection. Obviously, the first one is that you have to be a tenant. You have to have that landlord-tenant relationship. So if you're staying in a hotel or motel kind of situation, it's not going to apply. You have to be struggling to pay your rent due to a loss of income, a loss of work hours, or due to high medical costs. So that's the second requirement. The third requirement is that you do not expect to make more than $99,000 in 2020 or $198,000 if you're filing a joint tax return. So that's the income requirement. The fourth requirement is that you've used your best efforts to apply for government assistance, that you've gone to your local government and asked for help if they have that kind of program. The fifth requirement is that you've used best efforts to pay rent. So that means that if you're not able to pay the full rent, but you do have the means or the ability based on your other expenses to pay part of the rent, that you have to make that kind of effort to pay at least partial rent to the landlord.
Right.
And then the final requirement is that if you were evicted, that it would force you either into homelessness or into a shelter, or to move into close quarters with friends and family in order to remain housed.
Okay. And on that point that you said about best efforts to apply for governmental assistance, do you have to be approved for that housing assistance, or can you just show, hey, I applied, and then I did it wrong and I got denied? So does that show my best efforts as well?
Yeah, so you just have to make your best efforts is the rule. It's going to, and then it's going to be up to the tenant to demonstrate that to the court. So if you are able to save, those papers that you submitted, or your application, or your communication with the city, or whatever it is you have to show that you tried to apply, you can bring those to court to argue that you've made your best efforts.
Okay, now I understand. Thank you. Okay, so in order to be protected, this is a really common question. I don't know, all of them are very common questions, but does the tenant have to take any action at all, or do I just automatically expect that the judge is going to cover me on the CDC?
No, so you do have to take a proactive step, and that step is getting the declaration, filling it out, signing it, submitting a declaration to your landlord. You can deliver it in person, by mail, by email, or even by text message. The important part is that you get a copy of it to your landlord, and we strongly encourage you to keep some sort of record that you did provide that to your landlord. You can find a copy of this declaration on our website at trla.org. You can also ask your local court for a copy of the declaration. And I believe we're also going to be putting a link to it in the chat. Make sure to keep a copy of the declaration for your own records, and in addition to the one that you submit to the landlord. We would encourage you to take a picture of it so that you have that proof. It's important to note that when you fill out that declaration and when you sign it, you're declaring under penalty of perjury that everything on that form is correct. So if you sign it, but you know that part of it is not true, you can be subject to some severe criminal penalties, which include fines, jail time. And for non-citizens, these penalties might have some serious immigration consequences. So it's important that you read the declaration thoroughly, that you understand it, and that you ensure that everything is true when you sign it.
Oh, okay. I see. Okay. All right. So what if, is it too late to do the CDC? What if the landlord has already filed an eviction case in court? Is it too late?
It's not too late. Even after the eviction lawsuit has been filed, you can still give a copy of the tenant declaration to your landlord. And at that point, the court is required to pause the case until after December 31st, until next year.
Got it. Okay.
To have your case paused by the court, you must file a copy of that declaration with the court. You have to notify them in some way so that they know that you're covered and that you followed the steps in providing it to your landlord. We also have a notice to court form that's available on our website that you can file with the court. But again, remember to attach a copy of the tenant declaration so that the court knows that you've submitted it and they have a copy of it. And then you should keep a copy of everything that you file with the court for your own records and for your protection as proof. As long as the writ of possession has not been issued by the constable's office, you can still provide that tenant declaration to your landlord.
Okay.
The court is only allowed to proceed if, at that point, once you've provided the declaration, the court can only proceed if the landlord contests your declaration, makes the argument that it's not true, or that you lied in it, or that everything in it doesn't apply to your situation. If the landlord does contest the declaration, you get another hearing to go over that contest. And at that point, you can again present your evidence to demonstrate that, in fact, the CDC order does cover you and does protect you.
Okay. All right. Got it. So now, what if, how they have the CARES Act protections, right? So are people already protected under the CARES Act, or are there any other protections that the landlords must follow in reference to the CARES Act?
Yes, so for tenants who live in CARES Act properties, the landlord must issue a 30-day notice to vacate before they're allowed to file the eviction lawsuit.
30 days.
To confirm, to find out whether or not you live in a CARES Act covered property, we have a map that you can check out. It's located on our website, or you can go to txcaresact.org. That's txcaresact.org, and then you can look up your address on the map there and find out whether or not your landlord is required to provide you that 30-day notice. One other thing to note, is that the city of San Antonio passed an ordinance over the summer in July requiring what's called a notice of tenants' rights.
That's right.
So that requires landlords to provide that notice of tenants' rights along with the notice to vacate. And that notice provides resources and information for tenants. If the landlord fails to provide that notice of tenants' rights, they might be liable for a monetary fine up to $500. There is a process to report those kinds of violations, and if you're in a situation where your landlord has violated that ordinance, you should contact 311 and you can report it there.
Okay. So what should I do if I think my landlord claims that he did not receive the tenant declaration or refuses to even accept the CDC declaration?
So this does happen from time to time, unfortunately.
Mhm.
This is why we strongly suggest that you keep a record of everything and that you leave a paper trail, whether that's by text or email, or that you keep photos of the letter that you sent the landlord. I think the first step and the easiest way to solve this is to try just to have a conversation with your landlord, talk to them and
Okay.
see if they will accept it. If you're not able to get through, again, as long as you've provided it, again, you can just send it by email or send it by text or leave them a
Okay.
copy at their office and take a picture of it. And then if you have proof that you've provided it because you've got that text chain and you've got that email sent, then you'll be able to demonstrate to the court, if you need to, that you did provide it.
Got it.
You can also reach out to TRLA, to Texas Rio Grande Legal Aid, to apply for our services. You can call our intake line at 888-988-9996. Or if you're a resident in San Antonio, you can send us an email at righttocounsel@trla.org.
Right. Okay.
One more important detail is that the landlord is not required to sign the CDC declaration.
I was just about to
The only signature that's required on that form is the tenant's.
Well, I'm glad you made that point. But you know what? Is it illegal to record, to use the almighty cell phone, to record the interaction between me and the landlord giving it to him?
No, it's not. You have a right to record.
Oh, good. Okay. Alrighty. Another common question that we receive. Do I still need to pay my rent under the CDC declaration, or am I like cool and everything's chill and I don't have to pay anymore?
Yes, you do still have to pay your rent despite the protection offered by the CDC order. The CDC order does not forgive rent. And if you provided a tenant declaration to your landlord, you're signing under penalty of perjury that you're using your best efforts to pay as much rent as you can and on time. Also, if you're in court proceedings, you may end up with a larger judgment if you have not made any attempt to pay rent.
So the goal is to pay as much as you can, as quickly as you can, as frequently as you can, so that you can lower down your debts before December 31st. Is that what you mean?
Yeah, basically.
Okay.
Every situation is going to be a little bit different. Depends on the lease and depends on the specifics of the charges that your landlord have made.
Right.
But the general rule of thumb is to do your best to pay your rent on time and as much as you can.
Right. Okay. Now, can I still be evicted for something that's other than non-payment of rent?
Yes, you can be evicted for other reasons. If you stay beyond the end of your lease, or if you engage in criminal conduct, for instance, or if you breach your lease in some other way, your landlord can still evict you based on those reasons. So again, it's very important that you read your lease and that you're familiar with the requirements in there to find out what is a lease violation in your particular situation.
Oh my goodness. Okay. So this is like a lot of information, Matthew. This is like a lot of information. So help me out. I'm going to try to see if I can summarize everything that you just explained to us. Please do me a favor and just correct me wherever I need correction or if I missed anything at all. But what you basically explained to us is that we have basic tenants' rights. We have the right to notice. We have the right to repairs. We have the right to record, but the tenant must pay the rent. So I can't just say, well, you didn't fix this, so I'm not going to pay my rent. We got to pay our rent. But we also have the right to repairs. Okay. And then you said that we have an eviction process, like that's on our website, trla.org. You don't have to move just because you got a piece of paper that says, hey, you didn't pay your rent from last month, you got to get out. No, there's a judicial process that the landlord and the renter must follow with court proceedings. And the judge is the only one, right, that we got to listen to.
That's correct.
Okay. And then the CDC order temporarily pauses non-payment of rent evictions for certain tenants that meet the eligibility criteria under this order. And again, that can be found on our website. And then to be protected the tenant must take action. You can't just do nothing. You got to take action by providing a signed tenant declaration to their landlord or property owner or landlord representative, property management, and then always keep copies, declaration provided to the landlord. Never give away your originals, right?
Yeah, well, it's always important to document it and to make sure that you have proof that you provided it.
Right. Okay. And then if your eviction is in court proceedings, and as long as a writ, that writ of possession has not been issued by the constable's office, where they tell you that you got 24 to 48 hours to get out, then you can still provide a tenant declaration to your landlord, but also submit a notice to court, a form with a copy of the tenant declaration as well. And are those two forms also on the website, trla.org?
Yes, they are.
Oh, awesome. Okay. And this order does not forgive rent. It doesn't make the rent, the delinquent rents disappear. So the tenant should make best efforts to pay as much as they can, right?
That's correct.
Okay. So, okay. And then most importantly, the court can only proceed with the eviction if the landlord contests the tenant declaration. But the court must also provide a hearing date, and the judge issues a written order stating reasons and how to proceed. So that does give another opportunity for the renter to defend himself or herself, right? Or themselves, right?
Yeah, that's correct. And then the other final detail that I'd like to remind people of is that currently the protection only lasts until the end of this year, until December 31st. So come January, it's possible that these proceedings will be reinitiated and that the eviction will proceed at that point.
Okay, so yeah, I was going to ask what will happen when December 31st comes. So like you said, it might get reinitiated or something else might happen.
So at this point, the protection only lasts until the end of this year. We don't know, we can't predict what's going to happen after that. But if the proceeding is reinitiated and the eviction proceeds and a new hearing is set, then the tenant will have to defend against the eviction by arguing against whether it's a lease violation or whatever the cause is. You'd have to defend against the eviction in sort of the normal process.
Right. Okay. All right. Well, thank you. I mean, I really, really appreciate this information, Matt. And I know everyone that's listening on board. I see a lot of people in our chat. Thank you so much. I know that everybody's benefiting from this information. Now, I know that we're going to get to your questions, but first of all, what we're going to do is we're going to slide into the other part of our presentation before we get to all of your questions that I see that some of you have listed here. And Miranda Guerrero is going to go ahead and show us how to actually complete the CDC. Because there's a lot of times that that the CDC declaration is actually inappropriately completed. So Miranda, our other housing attorney, is going to show us exactly how to complete that CDC declaration. Miranda?
Yes, I am ready. How's everybody doing today?
Wonderful.
Well, while we're waiting for Molly to graciously bring up the website that I'm going to be referencing, as Molly reminded us, I'm going to be addressing how the CDC declaration should be completed by the declarant. As Matt mentioned earlier, the first and foremost step that the declarant, the tenant who's going to plan to use the CDC declaration, has to do is they have to find the form, and we're going to guide you to the website that we're going to be using. The form is available on our website at texasriograndlegalaid.org or TRLA.org. It's also available at the CDC's website. And finally, it's available at the Justice of the Peace Court here in Texas. So any of those resources would be able to provide you the CDC declaration in a blank form. Now, we're scrolling through the screen so that we can show you how to download the form from our website. And this is the form. This is the form that we've created.
Okay.
It is mimicking the language that the CDC order has instructed us to use. And I'm going to be going through some of the requirements that Matt has already covered. I'm just going to try to hone in on some of the finer points that I believe tenants need to be aware of when they're using the CDC declaration to their benefit. And I'm also hoping to prepare you for an eventual possible challenge to your CDC declaration. What we are seeing in court as attorneys is that landlords and their attorneys are challenging a tenant's CDC declaration. So they're taking folks to court as part of the eviction process. And when the tenant files the CDC declaration with the court, then the landlord or their attorney will actually ask the tenant questions about every requirement or some of the requirements that the tenant has said these are true and correct under penalty of perjury. So I want everyone to be prepared to defend their CDC declaration if indeed it is challenged. And so we're going to the website. Our website will tell you some information about the eviction process, some of the things that Matt has covered already. It will also talk about the CDC declaration. It has hyperlinks to resources, 211.org, where you can go to access resources. And are we able to bring up the PowerPoint? If not, I can just scroll through the CDC declaration. It's not a problem. Molly? Marcela?
PowerPoint is up.
Okay.
Marcella?
Well, I'll go ahead and continue. So the first item that you want to be aware of is that you have used all best efforts to access government assistance. Now, this can come in the form of rental assistance programs available through your local government. This can come in the form of charities, nonprofits that provide rental assistance. I believe we're going to be going through some of the resources that are available, at least in Bexar County and San Antonio, to tenants here, as well as some programs that might be available statewide. The other item that you need to be aware of, give me just a second here. And let me bring up my PowerPoint. And I don't know if y'all will be able to see it. But I did want to go ahead and have that available to me. Forgive the interruption.
Miranda, it's sharing the screen.
Oh, I'm so sorry. I don't see it. Do y'all mind if I just bring up my PowerPoint? Would that be okay?
Sure. Yes,
Okay.
of course.
All right, perfect. So 5 steps to be protected under the CDC declaration. Step 1, determine if you're eligible. Again, as a reminder to what Matt mentioned earlier, if you are a residential tenant, you are covered under the CDC declaration if you take the steps to assert that protection. If you live in a hotel or a motel, unfortunately, the CDC declaration or CDC order does not afford you any protections. Step 2, if you are a residential tenant, you must be behind on rent. So in the CDC order, it specifically addresses issues for not paying rent. If you are falling behind on rent or have fallen behind on rent, then the CDC declaration may afford you some protection. Please bear in mind that the CDC order explicitly prohibits protections to folks or tenants who are facing eviction for other lease violations. So other lease violations may include causing damage to the property, causing disturbances on the property. Anything of that sort is absolutely positively not covered under the CDC order and is explicitly barred. Number 3, you must sign the tenant declaration. Again, the forms that we've brought up on the website that are available on our website, at the port, or from the CDC's website directly, that must be printed out, that must be completed, that form must be signed. And step 4, you have to take a copy of it. The reason we ask or recommend that folks take a copy of it is that you have a copy of what you signed. Now it can be as easy as taking a snapshot on your phone. It can be as easy as scanning it, making a copy at the local CVS or Office Depot, whatever have you. And finally, you have to give the signed CDC declaration to your landlord. Now, it can be any one of the methods that Matt mentioned earlier: fax, email, text, hand delivery, mail. But you have to give it in order to obtain that protection. If you sign it and you stuff it away in your closet or your important papers, it does you no good. It has to be delivered to your landlord. And I recommend that you keep copy of whatever you delivered. So if you sent it by certified mail, great, keep a copy or keep the little green receipt. If you send it by text, make sure you save that text. If you hand deliver it, make sure that you note down who received the form. So if it's the secretary for the landlord or the receptionist, ask for their name, saying, "Hi, I'm so-and-so, your name is," and then just get their name, the date and the time that you delivered, and say thank you very much. That way you can remember who you've given that form to, right? And then you also need to be sure, that again, you've met your best efforts to receive or apply or seek government assistance. This means that you must apply for the government assistance or financial assistance from whatever resources are available in your area. And you have to complete your application. So unfortunately, what we've also discovered is that when someone applies for a government program, sometimes things fall to the crack. These programs are very, very busy. And so it's on the tenant to continue to keep in touch with that program or that agency about the status of their application, because ultimately it's going to be the tenant's responsibility to prove that they made their best efforts to follow through on that application. And if you can't say that in court under oath, then that's a problem. So you want to be sure that you apply for the benefits, that you keep copies of your application, that you keep track of the status of the application, and that you stay in touch and make sure that you followed all the steps possible. Now, of course, you can't control when you're eligible to receive the assistance, if you're going to be able to receive assistance. Some of these programs are already running short on funds, so just keep track, please. That's my recommendation to the folks that are listening. Now, the second recommendation, is the income. So as Matt mentioned before, individual income has to be less than $99,000 for year 2020. If you're filing a joint return, then it has to be less than $198,000 for 2020. If in the year 2019, you are not required to report any income to the IRS, you are eligible. And if you received a stimulus check in 2020, you are eligible for the CDC declaration. Number 3, you must show that you've experienced a substantial loss of household income. There is no COVID-19 connection required. So it's not on you to show that you've lost employment or you've lost household income as a result of the virus. You just have to show that you've had a substantial loss of household income. You have to show that your work hours were reduced or that you were laid off. The last qualifier or last requirement that I've not seen too much of, I have seen it, but not too much, is that you've had unreimbursed medical expenses that will likely exceed 7.5% of your adjusted gross income. So that's a little bit technical. You may want to look at your unreimbursed medical expenses to figure out if that's something that qualifies you if the income requirements are not met. So that's a little bit of a finer point. I just want to make everyone aware of that.
Okay. So Miranda, is
yes,
that
ma'am.
kind of like when somebody goes into the hospital because they've been exposed to COVID, or they think that they've been exposed and they have to get a test, and then they have that unreimbursed medical expenses of being taken care of when they had COVID and they had to be out of work for a while? Would that be like unreimbursed medical expenses?
It may rise to that level. You want to go ahead and look at the facts of the medical expenses, determine if they are going to be reimbursed or not reimbursed. So it's a finer point.
Okay.
And I just want to make everyone aware on the call that that is available, but it does require a little bit more investigation. So if anyone has any doubts or questions about that, please call us, seek out our assistance. I believe we've provided the intake line number. I believe you can also apply for our services online. So we have several ways of getting in contact with us other than this instructive webinar. But yeah, that is definitely an option for folks.
Wonderful. Okay.
And now, oh, okay. Now I see the PowerPoint. I'm so sorry, guys. If we could go on to the next one. Thank you. So the fourth requirement, as Matt mentioned earlier, you must make best efforts to make timely partial payments as close to the full rent amount as you possibly can, taking into consideration everything else that we face, right? We have food requirements, we have utility requirements, we have shelter as far as clothing, we have medications that some of us have to pay for. So all that weighs on our limited resources. I want to encourage everyone to make sure that they are doing their absolute best to pay what they can. If it's $5, pay $5. If it's $10, pay $10. If it's half of the rent, it's half of the rent. But please, please make sure that you are meeting this requirement, because the CDC order doesn't forgive rent. It doesn't let it go. It just gives you kind of a reprieve. And so part of meeting that reprieve requirement is that you have to make your best efforts to pay as much as you can, as close to on time as you can. So please, everyone remember that, to keep that in mind on top of all the other requirements that we have.
Got it.
Next slide, please. All right, so this one is pretty easy and straightforward. On the CDC declaration, you have to swear that if you were evicted, you'd become homeless, such as living in a car, or you'd be forced to move into a shelter. Right now, there are limited spaces, unfortunately, because there are restrictions. And then, or the last one would be that you'd be forced to move into a new residence, such as living with friends or family members, couch surfing, living in someone's garage for the time being. So you essentially show that you'd be forced to move into a smaller space with more people, which again is not conducive to preventing the spread of COVID-19. So if that's the case, which I think everyone would be able to meet if they're forced to be moved out of their home, then I think that requirement would be pretty easy to prove and meet. The next slide, please. All right. So 3 things to remember from this workshop. You must still pay rent or make a housing payment and comply with all of the terms of the lease. Nothing goes away. It's just a reprieve. So all the other requirements that are written into your lease, if you have a written lease, those still must be met. You must still pay rent or as close to full rent as you can. But you have to understand that all the fees, all the penalties, all the interest for not paying rent on time may still be charged or collected by your landlord. So just because you've signed this CDC declaration, you've given it to your landlord, you're paying as much as you can, as best as you can, the rest doesn't go away. It just gets pushed back. So please remember that. And then finally, the third thing to remember is that after December 31st, your landlord may require you to pay in full for all the payments not made prior to December 31st of 2020. And if you fail to make all those payments in full, you may be subject to eviction action. Now, all your rights that we've just discussed in an eviction action still apply. Nothing goes away, nothing gets taken away from you as far as your rights are concerned. It just means that if the payments aren't made in full after December 31st, then you may be subject to an eviction action, and then all your state rights and federal rights, if you live on federally subsidized properties, would kick in. But again, it's still a scary process, and I just want to make everyone aware that that is a requirement that may be asked of you, that will be asked of you at a certain point in time after December 31st.
Got it.
Next slide.
Okay.
Or Molly, do you have a question?
No, I was just saying got it.
All right. Now, for everyone on the call, if you are sitting in the middle of an eviction action and you're listening to this workshop and wondering, again, how Matt explained earlier, would the CDC declaration or the CDC order protect me? The answer is yes. But you have to you have to get the form, sign the form, give a copy to your landlord or the original and keep a copy. And then you have to tell the court that you've submitted this form, the CDC declaration, to your landlord. So again, my advice is get a copy of what you signed. It's the same copy that you gave to your landlord, and file it with the court. It's a very easy process. At the justice court, there is no fee for filing this form. I've not had the instance where I've had to file it at county court, but I'm going to be on the safe side and assume that there probably isn't a fee. But nonetheless, to file this form with the court at the justice court level, there is no fee. All you do is take a copy, walk up to the window, tell the clerk that you're in the eviction process, give them your name or your case number, and tell them that you want to file the CDC declaration. And they take it, they stamp it, they put it in your file, and then the court automatically has a process to notify all the parties that a CDC declaration has been filed in your eviction case. Now, again, going back to what Matt mentioned, there's a process for the landlord to challenge the CDC declaration, but at minimum, you've done your part and you've told the court that this is something that a protection you're claiming, and you've made the court aware. Because if you don't tell the court has no way of knowing, honestly, truly. So you need to tell the court if this is a protection that you're seeking by following all the steps and submitting a copy to the court.
Wonderful.
I believe that might be the last slide.
Okay.
Do we have
Perfect
any
timing.
questions or concerns? I know I speak a little fast, so I want to be sure that I
No.
cover anything that was missing or left unsaid.
We do actually have some questions. Not only that, we also have some wonderful visitors with us on Zoom. Mr. Hector Garcia with Hidalgo County, the Victims Unit, Ms. Yara Gomez, also with the Victims Advocate, and Ms. Madan Lujan. We did get your information. And to answer your question, yes, we are going to be providing this recording to the community as well. And I did get your email address, so we'll be sharing that with the community as well as yourself. So you'll have this available. And okay, and there is a question about the Texas diversion.
I'm sorry, Molly, you cut out a little bit.
They're asking, oh, how about now? Is this better?
Yes.
Okay. There's a question about how do you get involved in the Texas Diversion Program? Do we have a phone number? Do we have a website that we can go onto, or can people just go online and apply for it, like the NHSD website?
The Texas Eviction Diversion Program is a little bit more fine-tuned than that. So yes, there is a website that you can visit to get more information. I'll be sure to drop that link in the chat box quickly. But the Texas Eviction Diversion Program is a program that must receive a referral from the court. So you have, if you're in eviction process now, you have to ask the judge or the court to recommend you or refer you to the Texas Eviction Diversion Program. They already have it set up, but you have to explain that to the court. The court has to make that referral, and then it starts the process. So unfortunately, there's nothing proactive as far as I'm understanding, and correct me if I'm wrong, Matt or Liz, that there's nothing proactive the tenant can do as far as applying or seeking out that service beforehand. It must be at the court's referral, and both parties have to agree. So if you're all for it, but your landlord is not having it, again, it seems silly to turn down 6 months of rent, but believe me, some properties, some landlords have been saying that they'd much rather have their property back, and there goes the eviction diversion program as a benefit to the tenant. So both parties have to agree, and it has to be referred. The parties have to be referred by the court.
Got it.
And then I see that we've put it in there. Thank you.
Right. They provided 2 links. One is stoptexaseviction.org. You can also call toll free 1-800-525-0657 or 512-475-3800. Now, when you call the second phone number, 512-475-3800, you'll be able to pick option number 4, and then you'll get through to somebody that will tell you about the program as well. There's also another website link. You can go to www.tdhca. That's Texas. That's T for Texas, D for diversion, HC for Charlie, A for Alpha, state.text.us, and then / T as in Tom, E as in Echo, D as in diversion, P as in program, .htm. Okay, and that's another link that you can go to as well. I was just giving that information for the people that are on the phones. I do see that a lot of people have been respecting their privacy rights. They have been sending in emails and voice messages left and right into our right to counsel email. So one of us will be reaching out to you individually as well. So thank you for respecting the confidentiality clause. Somebody will be calling you shortly, tomorrow, the next day or so, okay? And other than that, do we have any other questions? Marcella?
Yes, we have two more. Marin Lujan asked a question. If families had not previously sought out government assistance, should they do so before filing the declaration or in tandem?
Yeah, I would say that it's probably best that they do so before filing the declaration, just to make sure that all their T's are crossed and I's are dotted. You know, the declaration requires that you've made your best efforts to seek government assistance. So it's also, I mean, you could make the argument in court that if you're making them simultaneously, if you're seeking assistance, if you've made the call and then you fill out the declaration, you can make the argument in court that is you making your best efforts to obtain government assistance. So it's sort of, you know, it would be best and it would offer you the most protection if you apply for assistance first and then fill out the declaration. But if you have a tenant, there's a tenant who's in a tight spot and is just learning about all this information at the same time, then clearly they would not have been able to do it beforehand. So applying for the government assistance at the same time that they file the declaration, I would say is, you know, you would have a good argument that the declaration is valid and should protect you in that situation.
Agreed.
Thank you. And then this person also had another question. Undocumented individuals may be concerned with going to court due to eviction concerns. What would you advise these populations? Is there a risk to them?
Yeah, that's a tough one. Miranda, do you have any advice or thoughts?
My thoughts are, if you're not there to explain your side of the story, the court won't know it. All right. The landlord's not there to talk to for you. So you always take a chance. If you're concerned about being, I guess, picked up, right, for lack of a better term, while you're at court, I would recommend that you implement a plan. So you check in with a friend or family member, let them know what you're going to be doing, where you're going, what to do. If they don't hear back from you by a certain day or time, but also be prepared. Courts are prepared with interpreters. Now, it may require you to call in advance and tell the court or ask the court, do you have an interpreter available? It's my experience that courts do provide interpreters at some courts. So be sure that you ask in advance, number one. Number two, you can also, I just see a comment from Ileana. Thank you, Ileana. Right now, since the courts are doing a lot of hearings by Zoom, you can ask for a hearing by Zoom. It's just a matter of contacting the court clerk or emailing the court clerk or faxing the court clerk and telling them, hey, can I have a Zoom hearing? And you can definitely do that. It just requires some advance notice. The clerk emails you with the link, the login information, and voila, you're in the Zoom court. You just wait, just like a normal court, to be called. And you say, I'm here. If you need an interpreter, again, for our folks that are bilingual or that speak languages other than English, be sure that you ask in advance for an interpreter. That way you have someone available to translate for you if you need that additional service. So those are just some tips. But again, it's always a pro and con. Like if I don't go, the court won't know my story, right? If I do go, then I have this risk. So I can't say which one is better. It depends on your circumstances, what you're comfortable with. And let's say if you don't show up, you opt to not go to court because you're just concerned. you always have the right to appeal. So even if you don't go, your right to appeal doesn't go away. It stays there. So that's an encouraging, I think, a fact for me to know and to share with some of my clients that are facing that particular conundrum.
If I could just add a couple of things to that. So just to emphasize what Miranda was saying, in addition to not being able to tell your side of the story, if you don't attend the hearing, it's very likely that the judge would issue, I mean, this happens in almost all of the cases in which the tenant doesn't show up, the judge is going to issue what's called a default judgment because the tenant doesn't show up. And that's basically just I mean, you still have the appeal process and you can appeal to county court, but the default judgment is basically an automatic decision against the tenant for failure to show up to the hearing. So it is, you know, there are consequences in the eviction context for not showing up. Another just quick detail is that if you don't have access, if you don't have reliable internet access by Zoom, you can also request a telephonic hearing if that's a method that's available to you.
And I was also going to add that for the last one, if you want to apply for the CDC protections, you could always tell the judge, hey, I haven't had the chance to apply for rental assistance. Can we reset my court hearing to a date where I can get this protection? Because I'm sure I would be eligible for it.
Okay, wonderful. So before we close our English session, I just wanted to go ahead and take an opportunity to share with you some resources available out there. We have like 2 minutes, so I'll go ahead and quickly share those with you. Our website, once again, trla.org, you can find sample forms and instructions on the CDC order that the attorneys just shared with you, as well as information on other housing issues. So we strongly urge you to speak to an attorney before signing the CDC and giving it up to the landlord, of course, because of that perjury issue. And to find out what housing, food, or any other needed assistance is available in your area, you can visit the website sacred.org, which is SACRD.org, which is sacred without the letter E, SACRD.org, which is a summation of all 211, 311, plus more agencies in San Antonio and Bexar County. And if you're on Facebook social media, you can locate a couple of community groups called Bad Weather Friends and another group called HIPPIE, spelled HIPPIE, Helpers. These are regular community members of San Antonio. No questions asked. They will get you what you need, food, clothes, bus passes, anything. It's a group of citizens in San Antonio that are ready to help you at a moment's ask. And then, of course, you can contact your local utility service provider to get on a deferred payment program to see if you qualify for utility assistance. If you live inside San Antonio city limits, you can contact the City of San Antonio Neighborhood and Housing Services Department, who's providing rental mortgage and utilities assistance. You can apply online at sanantonio.gov/NHSD or call them at 210-207-5910. Or if you live outside the city limits, you can go to what's called TRAM program for rental assistance, which is www.habctx.org/TRAM. And don't worry, a recording of this will be provided to the community after this date. So if we went too fast, we will have this available for you where you can play and pause as many times as you need in the future. Thank you, everybody, for joining us.